All right, let's go ahead and get started. Welcome to this. I don't think it's quite 20th, but we've done this now for many years as a collaboration between the ACLU of Illinois and the Chicago Lawyer Chapter of ACS and Mayer Brown. This event started when I was an associate at the firm, probably 2007, 2008. We missed a couple of years during the pandemic, but then we came back strong. And so there's a great tradition behind this event. I know many of you have been here multiple times, so thank you again for joining us. My name is Steve Sanders. I'm an alumnus of this law firm. I'm an associate dean and professor of constitutional law at the Indiana University Maurer School of Law in Bloomington. Before I introduce our panelists and let you hear from them, I want to thank, again, ACS, Megan Paulus, Peggy Lee, their team, who helped make this possible, the ACLU of Illinois, Kayla Flanagan, Emily Scott, Colleen Connell, Kevin Fee, who you'll be hearing from, their team, and of course, Mayer Brown, Joanna Horsnail, who is the managing partner of the Chicago office, Mike Scodro, who is co-head of the appellate practice here at the firm. The firm very generously provides both the space and lunch, so we really appreciate their consistent support of this event as well. Oh, and Tyler Moon also from the events staff who really, again, makes this flawless and very easy to do year after year. I want to, just as purely a point of personal privilege, Mark Kadish is here, a longtime pro bono director and fixture here at the firm, somebody I worked with when I was here. I always appreciate seeing him. And a former student of mine, Josh Felty, is here, who's clerking for Judge Kohler, will be joining the firm, and Zach Gossett, who I have the pleasure of working with, who's the chapter president of ACS at Indiana, where I teach. We also have, in addition to the nice full house here, the event is being live streamed, and so we have, I'm not sure how many, I assume several hundred at least, people who are watching this by live stream as well. It has been approved for 1.25 hours of Illinois CLE. You'll need to sign up for that if you are claiming CLE and need that. Okay, without further ado, our usual format for the Supreme Court term in review is we have 5 panelists. They will each take 12 minutes, no more, to talk to you about 2 cases, in some cases maybe a 3rd case. In our last case, Aziz Huck, he's going to end with some thoughts about the court, so we've only asked him to talk formally about 1 case. But our panelists are from this side of the table: Steve Schwinn, professor of law at the University of Illinois Chicago Law School and a longtime fixture on this panel in this program. Kevin Fee, who's the legal director of the ACLU of Illinois. Mike Scodro, partner and co-head of the Supreme Court and appellate practice here at Mayer Brown, who recently got a very nice recognition as a first-tier, top-band appellate lawyer from Chambers, USA. And if you're a lawyer, you know how much that means in the profession. Ami Gandhi, who is the sorry, me, I'm going to get the title correct. The Director of Strategic Initiatives and the Midwest Voting Rights Program at the Chicago Lawyers Committee for Civil Rights. And finally, Aziz Huck, the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School, and also author of a nifty little kind of nutshell-sized paperback I found recently that I recommend to all of you called The Rule of Law, A Short Introduction. So a very timely topic for our times. So once again, let's go ahead and get started. I've asked Kevin to start off the discussion. Each of the panelists will take about 12 minutes, and we always aim to leave 10 or 15 minutes at the end for your questions. So without further ado, Kevin.
Thanks so much, and thanks for having me here. I get the pleasure of starting us off on what I hope will be one of the day's higher notes, at least in terms of the substance of the case. I don't know about the presentation, but because this is a case with a good result, I think I can fairly say, mostly. It happened to be argued by my colleague Cecilia Wang of the ACLU, which we're very proud of, and it's the birthright citizenship case, Trump v. Barbara. So it's extremely complicated and fractured, almost 200-page opinion. So I won't do it justice here. Apologies if I talk fast, but it involves first and foremost the 14th Amendment and the text of the 14th Amendment, drafted, of course, after the Civil War as part of our second founding, expressly to repudiate Dred Scott's notion of separate but equal citizenship. And it states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So a remarkably clear text. Really, the only portion of that that's even arguably subject to real interpretation is the idea of subject to the jurisdiction thereof. But even that's been settled for a long time by both precedent and statute. In 1898, the Supreme Court decided the case of Wong Kim Ark, which was a case involving a Chinese immigrant that reaffirmed the broad constitutional principle of birthright citizenship and defined this carve out for subject to the jurisdiction thereof very narrowly to just deal with, Native Americans who are subject to tribal law and children of foreign ambassadors. Beyond that, everyone born here is a citizen. And about a half century later, you had the INA reaffirm this principle in statute. So you really have a trifecta here, right? You've got a very clear constitutional text. You've got binding Supreme Court precedent. You've got statutory reaffirmance, and you've got consistent interpretation over more than a century. In simpler times, we might have called this, a settled question. Enter Donald Trump, January of 2025, who issued an executive order purporting to strip children born of persons unlawfully or temporarily present in the United States of their birthright citizenship. In many ways, this was kind of a trial balloon for the Trump agenda. I mean, it very clearly signaled that they were going to find the furthest possible boundaries that they could and push against them as hard as they could. It was the very first executive order the president signed in his new administration, and it was promptly enjoined by multiple federal courts, ultimately became subject to a nationwide, class-wide injunction that was immediately appealed directly to the Supreme Court, where the Trump administration lost. They lost, and that is, given the nature of the question, I think worth celebrating. Justice Roberts wrote for the majority. The levy held, right? Essentially, the majority held that the point of the second founding was to make citizenship simple and expansive, right? In part to atone for the horrors of slavery and Dred Scott. Citizenship was not supposed to be a narrow and contingent matter. It was not supposed to be dependent on individualized, interrogations of the loyalties and intentions of individual Americans, right? So really, I should add, of course, always wanting to add sort of historical grounding to the ruling. Justice Roberts added that the 14th Amendment also just codified what had long been English common law, this concept of jus soli and the soil being tied to citizenship. So, this was not a surprise as an outcome, both because it was, settled law and because of what, I think Professor Steve Vladek of Georgetown calls the kind of constitutional politics of the decision. I think a contrary result would have been just immensely disruptive. It would have created a whole class of stateless individuals. It would have come at huge cost, I think, to the legitimacy of the court. But as many have recognized, I think as the initial relief of the outcome wore off, this was much, much closer than it should have been. It was a 6-3 decision on its face, but really 5-4, because Justice Kavanaugh separately wrote that the executive order was not, in fact, unconstitutional. It just violated statute. So theoretically, Congress could undo birthright citizenship, even if the president and the court could not. He did this in a sort of surprisingly short concurrence where he seemed to suggest Wong Kim Ark was wrongly decided because, times change. And, the modern world would be crazy to the authors of that opinion, appearing to embrace this sort of living constitutional principle that's usually avoided by folks like Justice Kavanaugh, like the plague. Thomas and Gorsuch dissented together, arguing for a concept of citizenship based on kind of a complicated notion of domicile. Justice Alito dissented on his own. And so you have a situation where 4 justices were basically willing to write that the Constitution does not mean what it says, right? And it does not mean what it's been interpreted to say for over a century. And that's pretty chilling. Now, that being said, I personally think it's wrong to suggest that this opinion creates some kind of like clearly politically coherent blueprint for overturning birthright citizenship. I think that the minority opinions are sort of difficult to stitch together. I mean, Gorsuch's idea of domicile, for example, would seem to grant citizenship to long-term undocumented immigrants, which would, fly in the face of Donald Trump's main political objective. But, what they do in a sense is somewhat more disturbing. I think that the minority opinions really evidence just a deep ideological commitment to deploying the most aggressive, even kind of contorted legal reasoning in service of the project of, shrinking the definition of what it means to be an American, right? Justice Alito's solo dissent is especially striking in this respect, and it just drips with the kind of policy-driven antipathy toward immigration that I think justices used to be more careful about hiding. And that's a good segue into the next decision, which is Mullen v. Doe, where Alito goes from the sort of solo, hot taker against immigration into the author of one of the more dispiriting majority opinions, I think, of the whole term. Mullen versus Doe involves TPS, or temporary protected status. The TPS is statutorily granted to the Department of Homeland Security in 1990. It allows the Secretary of DHS to designate the citizens of certain countries eligible to legally remain in the U.S. and work if they can't safely return to their country because of some temporary or extraordinary circumstance like a natural disaster or a war. You have to apply for it in the U.S. It's not automatically granted, but once you have TPS status, you have legal status. You're legally protected from deportation. DHS Secretary has discretion to grant TPS, but there is a statutory process. It involves consulting with the State Department, for example, and other federal agencies that might be impacted. Haiti was designated for TPS in 2010, Syria in 2012. That TPS designation was extended until 2025 when Kristi Noem abruptly removed protections for both of those countries, making over 300,000 legal immigrants no longer protected by the law. So Noem's cancellation was challenged in court, first, because the decision was made without following that statutory process that I outlined earlier. It's not even disputed that Kristi Noem did not consult with the Department of State, for example. But Justice Alito, writing for the majority, held that this doesn't matter because determinations about TPS are not subject to judicial review. And not just the ultimate determination, but the whole process leading up to the determination is insulated entirely from judicial review. So the DHS has unfettered total discretion. Now, as Justice Kagan pointed out in her dissent, this very, very expansive definition of determination is first of all, inconsistent with the way this very court defined that very term just a year ago in a different case. The ruling also didn't contend with the kind of parade of absurdities that comes with this kind of unfettered discretion. I mean, under this ruling, it would seem that the Secretary of DHS could de-designate a country for TPS based on a coin flip, and it would be unchallengeable. A future administration could extend TPS to every country in the world just because, right? It'll be a very interesting precedent to watch, in future administrations. But, separate from this challenge to the process of the cancellation, the ending of TPS for Haitian immigrants in particular was challenged as a violation of the Equal Protection Clause because it was motivated, at least in part, by racial animus. Now, I suspect I don't need to tell the folks in this audience that our president and others in his administration have repeatedly and publicly denigrated Haitian Americans, Haitian immigrants, in the most vile racist terms imaginable. He has said that they're poisoning the blood of our country. He has said that they are eating dogs and cats, eating people's pets. He's asked out loud why we have to have people coming here from quote unquote shithole countries like Haiti instead of places like Sweden and Norway. So there's really just a breathtaking record of racial animus that the district court faithfully compiled and examined that was totally disregarded by Justice Alito. So Justice Alito said that Trump's statements all, quote, expressed policy views that could rest on race-neutral justifications, end quote. Like, xenophobia or maybe national security, right? A single drop of race neutrality is apparently enough, which of course renders any examination of racial animus totally meaningless. I mean, poll taxes had a facially race-neutral, fig leaf attached to them too. So did Japanese internment camps. No one ever says, I'm doing this because of racist, right? So Justice Kagan, joined by Sotomayor and Jackson, wrote a blistering dissent where she pointed out, first of all, that this is not the law, right? The Arlington Heights test, which is the test that was applied by the Supreme Court here, asks the justices to consider whether racial animus was a motivating factor in the challenge decision. If it is even one motivating factor, that's enough. Justice Alito flipped this test on its head, saying that all that administration needs to do is come up with one plausibly race-neutral justification, and it's sort of a get out of the Constitution free card. Now, Kagan's dissent was especially powerful in taking Alito to task for not even having the courage to print the inflammatory and racist statements he was examining in his own dissenting opinion. He discussed them sort of categorically in the most sanitized terms imaginable. Justice Kagan put the words directly into her dissent, into the record of the Supreme Court for everyone to see. And she read that dissent aloud from the bench to emphasize its importance. Now, I'll end by saying, this Supreme Court is often criticized for driving to achieve, a particular result by ignoring the factual record, which is somewhat easy to do when you're a justice. Sometimes it's by ignoring or misapplying the constitutional standard. Here, the job of essentially defining racism out of existence required Justice Alito to do both of those things. And I think that the fact that Justice Roberts not only signed on to this opinion, but sort of allowed Alito to do his worst is a really infuriating indictment of where the court is at this moment. And I think you can really draw a straight line from this decision in particular back to some of the worst decisions in Supreme Court history, like Korematsu, and revive the tradition of sort of dancing around racism by pretending like you're talking about something else.
Kevin, thank you. Is the sound okay in the back? I thought I saw somebody kind of signaling like they had difficulty hearing. Audio is okay. Okay. Yeah, just make sure we hold the microphones up close to the mouth. All right. Steve Schwinn is up next.
Thanks, Steve and co-panelists, and thanks to the ACLU and Mayer Brown and the ACS again for hosting this wonderful, wonderful session. It's such an honor to be back with you all again this year. I'm going to talk about a couple of cases dealing with trans rights. And I guess we have 12 minutes, but I think we could probably do this in like 15 seconds. So it turns out trans people don't really have any rights. And for some on the court, trans isn't even a thing. That basically summarizes where we are over the last, say, year and a half with regard to trans rights at the court. And so we have two cases come to the court this term, one dealing with state bans on trans girls and women participation in sports, and the other dealing with conversion therapy. And I'll walk you through those in a second, but these come on the heels of about a year and a half streak at the Supreme Court of 5 other decisions not honoring trans rights in one way or another. And so last year we talked, for example, about the Skrmetti decision and the Mahmoud decision. Both came down last term. Skrmetti dealing with restrictions on conversion for minors, and the Mahmoud decision dealing with LGBTQ material in schools and a religious kind of carve out, or parents' rights to parent carve out for that. Well, it turns out there were 3 other decisions that came down too from the Supreme Court on its shadow docket, dealing with trans in the military, dealing with identification on passports, and dealing with a California law that said that school officials don't have to tell the parents if a child is using pronouns in the classroom that don't align with their biological sex. And so these, many or all of these were 6-3 decisions, just attacking trans rights, I think really is the only way to say it. And so these 2 decisions this term, the BPJ case and the Hecox case together as one, and the Charles versus Salazar case come on the heels of that kind of trend line, and the court's continuing it. So in the BPJ case and the Hecox case, these are two decisions that the court consolidated and treated as one. One came out of West Virginia with a 15-year-old girl who wanted to participate in girls' sports. The other came out of Oregon with a college female athlete who wanted to participate in female sports. And the state laws in both West Virginia and Oregon did not permit them to participate in girls' sports. What the state said in both cases is that this was a matter of safety, because on average, the state said that biological men are bigger, faster, quicker, and as Justice Kavanaugh noted, can jump higher than biological females, for whatever that's worth. And equality in sports. So what Justice Kavanaugh, as we'll talk about in a second, was very keen on is this idea that competitive sports are a zero-sum game. And what that means is that somebody loses and somebody wins, and that if a trans person is participating in sports, that means that a non-trans person can't participate in sports. And that turns out to be a bad thing by Kavanaugh's reckoning. So the two plaintiffs in these cases brought two claims, one under Title IX and the other under the Equal Protection Clause. Title IX, as you know, is a federal law that provides federal funding to schools, educational institutions on the condition that they don't discriminate by sex, and in this case, discriminate by sex in sports. The Equal Protection Clause was a sex discrimination claim. What the Supreme Court said was that both claims failed, that Title IX does not prohibit states from restricting sports to individuals of the biological sex of that sport, and that neither does the Equal Protection Clause. So I'll say just a quick word about both of them. As to Title IX, what the court said was that Title IX has long allowed segregated sports in educational segregated sports, and that the idea of not allowing trans people to participate in sports is just kind of part and parcel of that segregation. What the court said was that when Title IX was enacted back in the 1970s, sex was understood as biological sex at birth. And because Title IX allows sex segregated sports, it also allows discrimination against trans people in participating in those sports. Now, the court had to jump through a little bit of a hoop here with regard to the Bostock decision that came down several terms ago. You might remember that the court in the Bostock decision said that Title VII, employment discrimination, protects against discrimination by sexual orientation and discrimination by trans status. And so the question for the court here was, why doesn't that holding in Bostock, why doesn't that apply to Title IX as well? And what the majority said, again, written by Kavanaugh, what he said is basically Title IX's different. Title IX's different because sports. It allows sex segregated sports and therefore allows states to discriminate against trans people in playing sports. And that's fundamentally why Title IX is different than Title VII, not the maybe cleanest line of reasoning. But I got to say, sports really permeates this decision. So if you're a sports fan and you love to talk about sports, go read Kavanaugh's majority opinion in the BPJ case, because it's all about sports. On the equal protection side of it, the court purported to apply intermediate scrutiny, which is the test that we apply to sex discrimination. The problem, as the dissent pointed out, is that it was a really kind of diluted weakened version of intermediate scrutiny, which is going to be a problem for trans discrimination going forward. It may be a problem for sex discrimination claims going forward as well. It looked like the court kind of took its foot off the gas pedal with regard to sex discrimination claims under intermediate scrutiny, at least as they apply to trans discrimination. And I don't know what that's going to mean going forward, but didn't bode well for the plaintiffs in this case. And my guess is that it's not going to bode well in the future. What the court said for equal protection is that the state's two interests, safety and equality in sports, that's kind of enough for the court. That's all it really needs to hear. in the context of sports, right? Sports, that these are really important values that Justice Kavanaugh and the majority of the court really thinks that we ought to uphold, and that states have the right to uphold by banning trans participation in sports. And that was enough for the court. And the reason that I say that was enough is because the record here really wasn't developed. It wasn't developed at all. We didn't have a record on the equal protection claim. And so the more obvious choice for the court would have been to remand this case for fuller development of the record, to tease out the state's interest, to figure out, does this apply to all trans people or some trans people? Does it apply to all cis people or some cis people? Exactly how does this thing apply, and how does it line up with our traditional understanding of intermediate scrutiny for sex discrimination claims? The court did not do that. The court just went ahead and said, look, we'll accept the state's interest here. That sounds reasonable given the sports context, and so we're just going to take that at face value. Justice Thomas concurred. Justice Thomas concurred, basically saying that trans people are not a thing, that there's really no such thing as trans existence. Justice Gorsuch separately concurred, and Gorsuch reached out because Gorsuch was the author of the Bostock opinion, you might remember. And so Bostock, I think Gorsuch probably felt some extra compulsion to try to distinguish Bostock, which again, he did on the ground that Title IX allows sex segregated sports, whereas Title VII has never allowed, for example, sex segregated employment. And then Sotomayor dissented for herself and Kagan and Jackson. The dissent here actually agreed with the majority on the Title IX issue, but for a somewhat narrower reason, disagreed on the equal protection claim and called out the court for kind of letting off the scrutiny for intermediate scrutiny claims based on sex discrimination, and urged that the court really should have remanded this case. So that's the BPJ case. What that means now is that states can, if they want, ban trans participation in sports under Title IX and under the Equal Protection Clause. Now, some of these issues are percolating in the states' courts. I think some advocates are turning to state constitutional law and state statutory law to see if they can get better protection in those forums. We'll see what happens. The second case that I'm going to talk to you about today is the Childs versus Salazar case. This case deals with a Colorado law that banned conversion therapy. Conversion therapy is talk therapy that tries to persuade somebody that they're not really a part of the LGBTQ community, that they really are cis or straight. And what Colorado did was to ban that for professional licensed therapists. Well, one licensed therapist didn't like this, as we might imagine, and raised a claim that sort of sounds in free speech and maybe a little bit in free exercise of religion, and said that this law violates her free speech with maybe a little bit of shade of religion in there as well, that she wants to engage in conversion therapy, but the law disallows it. So she brought the claim. And what the court said here, by an 8-1 ruling, this was really interesting. By an 8-1 ruling, what the court said was that a ban on conversion therapy is viewpoint discrimination by speech, therefore subject to strict scrutiny, and Colorado's law fails. It analyzed it under traditional viewpoint discrimination doctrine. What it didn't do is treat the conversion therapy ban as part of Colorado's regulatory scheme on licensed talk therapists, which was one option. That's the way the plaintiffs pitched the state pitched its case. We're simply regulating talk therapy like we would regulate talk or provision of any sort of medical care in any medical context, right? The court didn't do that. Similarly, the court didn't bite at Colorado's argument that this was really sort of speech as action and therefore ought to be subject to a more forgiving level of scrutiny, that the talk here really was designed to provide therapy and not talk in the way that we're trying to persuade somebody or to contribute to our democratic discourse. Justice Jackson dissented, and what she said is this is basically regulation of professional speech and that Colorado ought to be allowed to do this. And like with every other Jackson decision that I've read, I'm going to highly recommend this one. It's on fire, and she's really, really good here, as she always is. And so that's the two cases, and that's what I'll leave you with. Thank you.
Mike Scodro.
All right, thank you. And thanks again to Steve and ACS and the ACLU for putting this together, as we've done so many times before. Good to see everyone. So my first case is actually, in reading it and rereading it, it occurred to me this is yet another case in the long line of cases, starting with Marbury, perhaps, that really come down to a fight over to keep or get a job. How many monumental Supreme Court cases fall into that category? Quite understandably, people do want naturally to keep or get a job. Well, this involved Rebecca Slaughter and her effort to keep her job. She was one of the 5 FTC commissioners in place when President Trump took office in 2025, and he promptly fired her and the other Democrat on the other commissioner after firing the chair, who was also a Democrat. By statute, the president is permitted to fire the chair, but by statute, the president is not permitted to fire any of the other 4 members, in this case 2, including Rebecca Slaughter, unless, and this is the statutory provision, unless they have engaged in malfeasance in office, they're inefficient, or they've in some way neglected their duties. Well, none of that was true here. The president didn't purport to invoke any of those rationales. Instead, the letter dismissing them simply said that their continued service was inconsistent with administrative priorities. Well, Rebecca Slaughter sued, seeking declaratory judgment and reinstatement as a commissioner of the FTC. The district court awarded summary judgment. The DC Circuit declined to grant the federal government a stay pending further appeal, but the US Supreme Court on its emergency docket did grant a stay of the district court's order of reinstatement, and furthermore took the case, rather not unprecedented but unusual step of taking the case, granting cert on the merits before there was a judgment below in the appellate court. So the case came up to see whether the president is entitled to, it has to live by the statutory limits on the dismissal of FTC commissioners. Well, the reason Slaughter had won below was because of a case, and I'm sure many have heard of this case because it's been talked about a lot since the court agreed to hear Slaughter, and that is Humphrey's Executor. That was a 1935 decision by the court holding that then President Franklin Roosevelt could not remove, dealing with the same agency, an FTC commissioner because he was subject to the limitations of under statute on the removal. As the Supreme Court majority notes here, the death watch has sort of been on for some time on Humphrey's Executor. There have been reasons to believe, based on prior opinions, that the court was headed in the direction of overturning that 1935 decision, and that's exactly what happened in this case. The reason the court reaches that conclusion here is something known as the unitary executive theory. Put simply, this theory holds that the Constitution entrusts the president alone to faithfully execute the laws, and to do so, the president needs to be able to appoint, obviously with Senate approval, but to appoint and remove the people that are actually undertaking the day-to-day work of the executive branch, so he can fulfill that constitutional duty. Well, you could tell which way the winds were blowing by the opening sentence. The Chief Justice held nothing back, I think, in the opening sentence, which states nearly 250 years ago, the framers decided to vest the executive power in one person, a president of the United States of America. That is a concise statement of the unitary executive theory, and that's exactly what this opinion proceeds to vindicate. The opinion walks through the framing era history, essentially concludes that the first Congress, in the immediate aftermath of constitutional ratification, actually debated presidential removal power and concluded that the president had virtually unfettered authority to remove. Goes on past the first Congress to say that that was also true of how early presidents understood their authority, and that it was actually true of a number of US Supreme Court decisions, chiefly a case called Myers that was authored by a former president, then Chief Justice Taft authored that opinion in 1926, upholding President Wilson's authority to remove, without any restrictions, to remove the postmaster of Portland. So that obviously was an interesting dispute. As the majority notes, the nature of the president's dispute with the Portland postmaster has been lost to history. So we'll just have to guess at what might have incited that feud. But in any event, of course, Humphrey's executor followed just 9 years after that Myers decision and held to the contrary with regard to the FTC. The reason for that, the court concludes here, in rejecting and overturning Humphreys. In the court's words, if anything more is left of Humphreys, we overrule it. The reason the court gives for that is that the FTC, as it was initially understood by the court in Humphrey's executor, and even more so today, they would said, there has simply been a misunderstanding. The court got it wrong because they didn't understand exactly what the FTC does. The premise of Humphrey's executor is that the FTC wasn't really engaged in executive branch activities. Instead, to use the court's word, it was engaged in quasi-judicial and quasi-legislative activities. Well, the modern court says that was not true in 1935, and it certainly isn't true today. They cite the fact that the FTC promulgates rules, conducts investigations, it brings lawsuits on behalf of the government in federal court, all things that executive officers typically do. Therefore, Humphreys is out. Going forward, these bipartisan, multi-member bodies that have these for-cause statutory protections on membership, the president can now remove those folks at will. Now, the court goes on to note that there are limits to this, but the court doesn't articulate what they might be, so we can expect future litigation. We know one thing for sure. The Federal Reserve Board, in another case, which we're not going to talk about today, but essentially it's a case called Cook, we know the Federal Reserve Board is not subject to this new rule. That is, the president is restricted in his ability to remove members of the Federal Reserve Board. In essence, it seems like a sui generis conclusion by the court, in essence, because doing so would be extraordinarily disruptive to the markets. I think that is, in essence, sort of part of the rationale the court has advanced.
The justices, like all of us, care about their 401k.
Exactly, they are right. So we know that is off limits. The court goes on to say, look, don't worry, this doesn't cover every sort of entity created by statute. Georgetown University, the Boy Scouts are created by statute. The majority note. So those are, the president can't dismiss the president of Georgetown without, doesn't have that authority. So we'll get to those things later. More importantly, the court reserves a decision on things like non-Article 3 judges, so members of the tax court, the Court of Federal Claims. That is expressly left open by this decision. And I think we can all expect to see cases teeing up that question in the very, very near future. Justice Sotomayor's dissent, there's a Gorsuch concurrence. I'll just note that what Gorsuch basically does is, look, we've just protected executive power. Now we have to do the same with legislative and judicial power. We can use these other doctrines like the major questions doctrine and non-delegation to ensure that courts and the legislature, Congress, also claw back some of the authority that agencies have. So it's basically an open cry to take still more back from federal agencies, this time not to go to the executive, but to go to the legislature and the courts. Justice Sotomayor, joined by Justices Kagan and Jackson, writes a vigorous dissent, pointing out that these bipartisan multi-member bodies with for-cause removal protections are really essential to tackling difficult problems with some immunity from day-to-day politics and partisanship, and that they've been part of the fabric for a long time. Indeed, Congress has relied on the ability to protect members of these commissions and so forth in delegating authority to these agencies. Now, I'll spend a little bit less time on my second case, which takes us in an entirely different direction. This is a case called Chardy versus United States. This takes us into the world of the Fourth Amendment and the always interesting intersection between Fourth Amendment and technological developments in the U.S. Supreme Court, as the court is sort of following it, getting up to speed on these changes in technology. This was an Elena Kagan decision joined. It's an interesting collection. It's Justice Kagan joined by the Chief Justice, Justice Sotomayor, Justice Kavanaugh, Justice Jackson with the concurrence by Justice Gorsuch. So it's an interesting, for those who think that the court always or sort of reliably decides important issues 6-3 and the same 6-3, not so here. So it's an interesting case involving what's called geofence warrants. Now, a geofence warrant, I had to learn what that is as this case made its way through the courts. A geofence warrant, essentially the government law enforcement goes to a court and says, here is a virtual fence around a crime scene. We are going to serve this warrant on a third party, a Google, an Uber, a Lyft, an entity like that has the ability to see where people are, in this case, based on their cell phone. Google has a feature called Google or Location History, which you can opt into. And location history pings your phone and basically figures out where you are within 20 meters accuracy. It can also tell elevation, and it does so every 2 minutes, give or take, throughout the day. So it is an extraordinary catalog of your comings and goings if you've opted into this program. In this case, there was a bank robbery outside Richmond, Virginia in 2019. There were some sightings of the person who committed the robbery. It was an armed robbery, but they had no idea who it was. Law enforcement sends a geofence warrant signed by a judge to Google. The way that the warrant will work is Google will provide a list of all the numbers that were within that area an hour, half hour before, half hour after the robbery took place. Then the law enforcement will somewhat further narrow that group, and then they go through another iteration. And finally, at the end, they get de-anonymized data, the actual names and phone numbers for 3 people. One of them was Mr. Chatri, who then sued, claiming that, not sued, but in defense, after he was charged, claimed that the warrant was inadequate because of this back and forth, where this sort of 3-tiered structure to the warrant. Well, none of that mattered ultimately to the lower courts because there was a sense that this was not a search in the first place. And so that was the question that went to the Supreme Court. Doesn't matter if the warrant's defective, if there's no search. Is there a search? Justice Kagan writes for the majority and says yes. Why? Because you have a legitimate expectation in privacy, even if you have opted in to this program. And that's because we all carry cell phones as a matter of daily life. Cell phones are in essence sort of essential, as the court had held just a few years earlier in a case that used a much rougher way of finding people by their cell phone, a case called Carpenter. And the majority said, look, this basically follows from Carpenter. And you have a legitimate expectation. The fact that you have to opt into this program doesn't change that. You opt into everything on your phone. You know, the phone is only useful because you choose to use it and use the functions on it. And therefore, that can't be a reason that you lack a legitimate expectation of privacy. So that's the gist of the opinion. One thing that I'll note is there has been some back and forth in the court in the last several cases, including the case involving GPS on a car, over whether we think of the Fourth Amendment as is it a violation because you have an expectation of privacy, or is it a violation because you own the property and the government is trespassing in a common law sense on your property? The majority here solidly reaffirms, over concurrence by Justice Gorsuch, that expectation of privacy remains the lodestar. It's not about sort of common law privacy rights.
Anytime there are important voting rights decisions coming out of this court, our first call is always to Ami Gandhi to be on the panel.
Good afternoon. Thank you so much for the opportunity to be here today. I'm Ami with the Midwest Voting Rights Program of Chicago Lawyers Committee for Civil Rights. We have the privilege of being able to help voters over the phone and in person during elections, including calls to the 866 Our Vote hotline. And you don't need me to tell you that it's a time that is very disheartening and confusing for voters. And one of the reasons for that is the Calais Supreme Court decision, which I'll be summarizing today. The Calais case is about what constitutes modern day racial discrimination in voting and who gets to decide that and define that. It relates to redistricting in Louisiana. And in Louisiana, the Black population is making up nearly 1/3 of the Louisiana population. But the state's 2022 congressional map created only one majority Black district out of 6, arguably cracking apart the voting power of additional significant Black communities, including in places like Shreveport, Baton Rouge, and several other communities. Civil rights organizations have pointed out that effective representation can have an impact on whether communities receive attention and resources needed in our daily lives, including for transportation, economic development, education, and other local needs. In other words, whether someone's vote counts and whether they have the opportunity to elect candidates of their choice. In Louisiana, the Power Coalition for Equity and Justice and the Louisiana State Conference of the NAACP challenged that map I described under Section 2 of the Federal Voting Rights Act, arguing that the map divided Black communities in a way that weakened their collective voting power. After a federal court agreed that their challenge was likely to succeed and several procedural complexities at the district court and Fifth Circuit level, the Louisiana legislature then passed a new map in response to a court order to comply with the Federal Voting Rights Act, and they there included a second Black majority district. However, a group of, as they called themselves, non-African American voters challenged that new map, claiming that it was unconstitutional, claiming that it was an unconstitutional racial gerrymander. And I'll explain to you what the legal question was once this got to the US Supreme Court. Given that Black voters of Louisiana had argued that they would not have had the sufficient opportunity to elect the candidates of their choice unless that map were changed, the question before the Supreme Court was the Louisiana map following a Federal Voting Rights Act court order to address racial discrimination itself unconstitutional, or was there a compelling enough interest for the state of Louisiana to use race in that way to address discrimination as it was ordered by a court to do? The main takeaway from the devastating majority opinion was that compliance with Section 2 of the Federal Voting Rights Act can serve as a compelling interest to justify race-based redistricting, but only if the Federal Voting Rights Act requires a race-based map. And then the court went on to explain exactly under what narrow circumstances that sort of requirement would kick in. The court also stated that the Federal Voting Rights Act imposes liability only when there is a strong inference that intentional discrimination occurred. The court called their decision an update, but they made significant changes to the law, and specifically to the long-established threshold test called the Jingles test that Black voters and other voters of color have long been required to meet to prove vote dilution and how districts are drawn. I'm going to briefly summarize each part of the longstanding vote dilution test and explain how the Calais court decision changed it. Under Jingles, the long-established test, the community of color, or as it's called in voting rights cases, the minority group, must be sufficiently large and geographically compact to constitute a majority in a single member district. But under Calais, Black voters bringing a vote dilution claim under the Voting Rights Act must not use race as a redistricting criteria in drawing maps that they propose to the court. And maps, the court further ruled that maps proposed by impacted voters must meet all the state's legitimate districting objectives, such as the state's, in this case, Louisiana, specific political goals, including partisan advantage and protecting incumbents. There were additional changes to the Jingles test. Traditionally, the minority group must show that its members tend to vote as a block for the same candidates and that the white majority votes sufficiently to block that preference, to block the opportunity for communities of color to elect the candidate of their choice. But under Calais, the fact that voters of different races consistently vote for different political parties is no longer relevant on its own. Instead, plaintiffs have to now show going forward that race and not just political affiliation is the reason behind voting patterns. The court, in its opinion, claims to be disentangling race and politics, but now it is tipped so far that partisan advantage gives a kind of immunity for racial vote dilution going forward. Under Calais, also, other parts of the legal test are impacted. For example, the present day disparities that may be effects of societal discrimination have much less weight. And so there's a lot more focus going forward on current data and data of intentional discrimination. You might be wondering, how could the court have even reasoned this way? And some of the points that they state include, they actually list out 4 reasons for their changes to the legal test. They name vast social change, in case you didn't know that had happened. They also name the 2-party system, the bar on federal courts being able to decide partisan gerrymandering claims that we've talked about in past years, and then also modern computer technology, but specifically the court mentions it to cast suspicion on and assume ease for voters who might try to go about challenging maps. It's certainly a departure from precedent, the Calais decision. And just 3 years ago in the Allen versus Milligan case, the court had unequivocally reaffirmed the traditional jingles effects-based framework. And now the court has effectively overruled that precedent, but has said it under the guise of merely updating it. I wanted to sum up for you some of the impact of those changes to the legal test. This Calais decision encapsulates the thinking that racial discrimination is blatant when we all know that it's not. It states that acknowledging and acting on other forms of discrimination is itself racial stereotyping and discriminatory. Vote dilution has been a significant part of the story of racial discrimination in voting. And one of the points that the dissent made, which was very powerful, is that taking away choices on the ballot can be different to measure and observe compared to other types of more blatant discrimination. And it can lead to undetected, uncorrected, and undeterred racial discrimination that still gets in the way of voter opportunity. The dissent pointed out that the majority is destroying Section 2 of the Federal Voting Rights Act by replacing the effects test with an intent test, and how much more leeway a state now has, how much less legal consequence in diluting voting power of Black voters and voters of color. The dissent powerfully points to a very specific legislative change to the Voting Rights Act in 1982 to reject exactly what the majority concludes. And again, emphasizing now going forward the intent of a change to a map versus the effects. So that means we're now going back to an era of what voting rights laws were pre-1982, certainly less effective than more modern tools. And it is going to be much harder, if not impossible, for voters now to use a legal test to get an unjust map changed. This opinion lays the groundwork for the most severe reduction of minority political representation since Reconstruction. And it's been absolutely devastating to Black communities, Latino communities, and all of us who want to see a multiracial democracy. You might have seen the headlines in the news, there was immediate disruption and confusion in elections and voters' ability to elect the candidates of our choice, including in the South. We saw the headlines coming out of Louisiana, as I mentioned, Tennessee and Alabama, and there's a lot of volatility in this legal field. In Alabama, in the very case that reiterated the precedent under the Voting Rights Act just a few years ago, that progress was reversed. And Black voters in Alabama, after this Calais decision was announced, then after many rushed procedural steps, they had to go back to a previously discriminatory map that had been drawn a few years prior. And this is going to allow those discriminatory maps in the Alabama case to proceed with primaries coming up on August 11th. And it seems like the clock is running out for any further changes to the map. The latest development in what just a few years ago had been a heartening decision in the Milligan case. There will be ripple effects even beyond congressional districts that we're all bracing ourselves for. There is, however, some ambiguity in the Calais decision, and today is not the day to lay out all those legal strategies, but it's heartening from where I sit that there is phenomenal work underway for new legal tools. We're going to certainly need new legal tools at this stage, including federal legislation, state protections, new litigation strategies, and most importantly, people power for people to turn out and demand better for our voting systems. This is also happening during a time where, I don't need to tell you this, that it's been an extremely disruptive and unusual effort for mid-cycle redistricting forced from the presidential administration and still leading to uncertainty. I wanted to highlight that there are mechanisms to try to address these problems. And even here in Illinois, there is an Illinois Voting Rights Act bill of 2026 that is the opportunity to enshrine a modern post-Calais state level protection, at least as some step forward. And I'll briefly mention in closing that another significant Supreme Court decision relating to voting rights from this term was the Watson decision, where the Supreme Court rejected the attempt to restrict vote by mail. And there is still a lot of noise in the arena for vote by mail. And it's really important that voters get the most accurate, up-to-date information about our rights. But in the Watson case, the Supreme Court decided that mail-in ballots need not be received by Election Day in order to count, and rejected the arguments to the contrary. That was certainly a boost of confidence for voter access, but much more work remains to be done. And people who our civil rights laws were meant to protect are still part of this country and will still keep fighting. Thank you.
Kevin began with a bright spot case. What's a bright spot is relative these days, of course. Aziz Huq will end with another bright spot case, but instead of doing a second case, we've also asked Aziz to do something that we think this panel can make a contribution to, and that is to give us some larger thoughts, some capstone thoughts about the state of the court today. So, Aziz.
Thanks, Stephen. Thanks to Mayer Brown, to ACS, and to the ACLU for organizing this wonderful annual event. I'm going to talk about Learning Resources v. Trump, a 6-3 decision in which the court invalidated 2 sets of tariffs imposed at the beginning of the second Trump administration. Writing a couple of days after the Learning Resources decision was handed down, David French in the New York Times described it as possibly one of the most important decisions of the century because of the way it constrained presidential authority. I have great respect for David, but I think he is wrong. I think that the Learning Resource decision certainly has an immediate fiscal effect because of the 80 million in tariff revenues that had to be returned, but both as a matter of trade policy and as a matter of constitutional law, I do not think that Learning Resources will have a durable effect. But in my broader remarks, I'll say a little bit about how I think one should fit that in to a larger account of what the court is doing. So at the beginning of his term, this term, the president imposed tariffs first on Canada, Mexico, and China on the allegation that these countries were supplying narcotics. Quebec, that famous narco state. And then a second set of global tariffs, famously on an uninhabited island occupied largely by puffins, if I recall correctly, on the basis of an imbalance in fiscal flows related to trade, called a balance of payment disequilibrium. The tariffs imposed changed on an almost daily basis. So, for example, tariffs on China went from 34% one day to 84% a few days later, to 125% a week later, and then up to 145%, and then back down again. These tariffs were challenged in two separate proceedings, one in DC, one in a proceeding that eventuated in a ruling from the Court of International Trade in the Federal Circuit. It was the latter that went up to the US Supreme Court, which ruled in an opinion by Chief Justice Roberts, 6-3, that the tariffs were outside the authority delegated to the president pursuant to the relevant federal statute, a 1977 measure called the International Emergency Economic Powers Act, or IEPA. There are concurring opinions by Justice Gorsuch, Justice Barrett, and Justice Kagan, all of which concern a question of interpretation, which I will mention, or which I'll briefly explain, called the Major Questions Doctrine. And then there is a dissenting opinion by Justice Kavanaugh, in which Justice Thomas and Justice Alito join. The core of the case concerns the language used in the 1977 IEPA statute, specifically two words. IEPA has a long list of measures that the president can take after having designated a national emergency. Among those measures are the words regulate and imports. According to the government, the regulate import language in IEPA, which was drawn from an earlier statute called the Trading with the Enemy Act, authorizes the president to impose taxes on goods flowing into the country. The majority rejects that principle on two grounds. The first is applying the ordinary instruments of statutory interpretation. The term regulate does not include the term tax. So the core of the holding is about the meaning of the word regulate. And the court offers a series of arguments that are familiar to law students taking statutory interpretation classes. For example, the word regulate is not used elsewhere in the US Code to confer taxing authority. If you look at the other words in the list that comprises IEPA, it's hard to understand why the word regulate would be used expansively in that sense, particularly given the specificity with which Congress has used other words. And were the word regulate to be used in that broad sense, at least in some substantial number of cases, it would be unconstitutional because the Constitution prohibits taxes on exports. The second strand of the majority opinion turns upon a doctrine called the Major Question Doctrine, pursuant to which the court is not willing to read in vast economic or political changes into statutory language that is vague or general. The idea here is that Congress doesn't hide mouses or elephants in mouse holes. That's the language from an early case called FTA v. Williamson. This Major Questions Doctrine was revived late in the Roberts Court. It was used to strike down the EPA's effort to regulate climate change-inducing pollutants, carbon-based pollutants. It was used to strike down the Biden-era student debt relief plan and a number of COVID-related measures. This is the first time it's been used against a Republican president. And it's that flip that generates the slew of concurring opinions. Justice Gorsuch, demonstrating, I think, that one would never want to have him at a dinner party, goes after every single one of his colleagues with respect to the Major Questions Doctrine and explains why they are all wrong in extensive and, well, let's just say extensive detail. Justice Barrett responds to him, Justice Kagan responds to him. In the dissent, Justice Kavanaugh makes what, in my view, what is actually not an implausible argument. The non-implausible argument is the Trading with the Enemy Act, when it was enacted, was understood to permit the taxing of imports. It was understood to do this with respect to wartime, but then as it was applied over time, came to be understood to also apply in moments of national emergency. And that was the understanding that was imported when Congress reforms the Trading with the Enemy Act and codifies emergency powers in the form of IEPA. I don't think that that's a bad or an off-the-wall argument. I think it's a plausible statutory argument. I said that there's not a constitutional takeaway from this decision, and let me explain why. I think that there are two big constitutional issues lurking in the background, but neither of them actually touch ground in this case. So the first is the majority opinion has a long section about why the power to tax is distinctively Congress's. And one might read that and think, well, that has some impact on the way that the court reads the statutory language. But it's perfectly possible to do all the statutory interpretation moves without any of the constitutional baggage that the court has introduced. And indeed, in other cases, particularly shadow docket cases concerning appropriations, the court has shown no interest or attention to the federal executive's ability to play fast and loose with the fiscal powers that ought to belong to Congress. For example, entities that challenge the failure to spend or withholdings of federal funds have had, in general, a hard time getting remedies from the US Supreme Court. The second really important question that is lingering, I think, in the wake of learning resources is the statute says, IEPA says, the president has these powers if there is an unusual and extraordinary condition. Well, the United States has run a trade deficit, which is the unusual and extraordinary condition for the second set of tariffs, since 1970. In what way is that unusual and extraordinary? The key constitutional question is, does the court have the authority, pursuant to Article 3, to review the factual predicates of an emergency? That's a question that matters with respect to the National Guard case, that concerned all of us because it concerned what would happen in Chicago, and it concerns the Alien Enemies Act. Okay, how do you understand, or how do we think about the larger frame of the court in 2.5 minutes, Steve? I know how much time I've got left.
Someone who could summarize the rule of law in a 30,000-word pocket nutshell can do this. So
I'm really glad that's already being used against me. So this is an argument that I made in the Atlantic last week, and here's how I would understand the relationship between the court and this presidency. I don't think it's an explanation for the court as a whole. It's just the court versus the presidency. The court has a number of long-term projects that Chief Justice Roberts has been building on since the beginning of his tenure, and provided that we're in the slipstream, provided the administration does something within the slipstream of one of those big projects, it wins. When it tries to freelance, particularly in a way that's going to embarrass the court, that's the Trump versus Cook case in the Federal Reserve, or where it's gonna ruffle the feathers of a constituency that the court thinks is important. That's the business community that's at stake in the learning resources case. The court's going to get off the boat. So what's really important to understand are what are the court's big long-term projects. And I think here I'm going to identify them with Roberts, but because the conservative majority is 6-3, there is wobble or shift to the right on all of these three projects. So here are the three projects in a minute. The first is the concentration of political power within political elites, as opposed to the people at large or the vagaries of an election. How does that manifest? So it manifests in gerrymandering, or the permission to partisan gerrymander, which gives power to the people who draw the map, right? Who are the party hacks in whatever state you're in. Campaign finance law, which we haven't talked about, the National Republican Senatorial Commission versus FEC decision, a decision that empowers political parties who are relatively an elite, but the most important group that had been empowered by campaign finance reform as an empirical matter are a very small number of high dollar, billion-dollar donors who are able to drive, particularly on the Republican side, drive the party to the right. So the court's jurisprudence disables the people at large, and it empowers a very, very small political elite. That's project number one. Project number two, neuter the effect of the 14th Amendment. The contrast that I would draw between Doe v. Mullen and Calais is the contrast between, in one instance, where you have overt evidence of bias against a minority, the court literally blinks. And in Calais, the court goes out of its way to interpret a federal statute to mean something it plainly did not say or mean in order to be colorblind. So when the law tries to remedy or help disfavored racial minorities, the court torpedoes it. And when the law tries to burden those same minorities, the court ignores racial bias. That's not even-handed colorblindness. That is a reversal of the function and the effect of the 14th Amendment, and it is consistent across the case law. The last time that a plaintiff of color won, and won all the way to an actual victory on an equal protection claim in the Supreme Court, not just won like one part of a test, not just won, well, you get the right level of scrutiny, but won, was Loving v. Virginia, like 1970, right? And then think about how many white plaintiffs have won. And then the third part of the court's project is, as Mike said, the concentration of power within the executive branch. I don't believe that the anti-delegation framing or doctrinal proposals that particularly Justice Gorsuch has argued will in fact empower Congress. Congress can't be empowered because the sources of congressional weakness adhere in the structure of our party system and the fact of polarization. So a world in which the unitary executive doctrine is law, a world in which Congress is increasingly actually disabled from delegating by the anti-delegation doctrine, is a world in which necessarily the initiative falls to a small group of people embedded within the federal executive, and in particular in the White House and not in the federal agencies. And so the effect of the doctrine as a whole is to, I think, create a world that is really safe for people who look and spend and have the resources of the justices.
Let me just say how ironic it is you're applauding that, but I know you're not applauding the thought, you're applauding the presentation and the quality of the analysis. I hope you agree. I mean, I've done this panel for a long time, just how rich it is to see top flight, the results you get when you have top flight litigators, academics, advocates, you know, explaining very clearly these complicated cases and giving us all so much to think about, such an education in an hour. So with that, we have we like to get you out of here by 1:30, but we have about 12 minutes for Q&A. We do have a microphone in the back. And so if you have a question, please raise your hand so I can see you and we will bring the microphone to you. Jerry, from the ACS Chicago Lawyer Chapter Board.
This question particularly for Ami, Gandhi, and anyone else who would like to weigh in. Regarding the Calais decision, and I hope I'm remembering this correctly, was there some dispute over the timetable for when the decision would become effective so that states that wanted to use maps that would have otherwise not been permissible to sort of accelerate the timeline so that they would then be able to use the maps and perhaps reschedule midterm primaries when that wasn't the court's normal practice in terms of when their decisions would become effective?
That's a great question. And yes, there has been inconsistency, to say the least, in terms of when it's too late or when it's early enough to make a change to the election system under the Purcell principle. And we see that play out over different decisions having inconsistent, even by the Supreme Court, having inconsistent timelines that are considered acceptable or not to make election system changes, including redistricting maps. And we've seen some extreme examples of that post-Calais, including voters even thinking about time urgency. That's the idea behind it, right? The idea behind the so-called Purcell principle to supposedly keep voters safe from last-minute confusing changes. But in Louisiana, the election date was changed. Some voters had already voted, depending on the kind of ballot that they had, or people participating from the military, for example. And some voters went to the polls and were told, you will have to come back to vote under redone maps at a later time. And so that has definitely been part of the injustice felt by the Black community in Louisiana. And then on the flip side, other times when even in the name of justice and meeting the legal tests, voters won relief, but in a practical sense, we're told that they are going to have to wait even a matter of years before being able to vote free from discrimination.
Front.
Thanks. It's great to see a incredible turnout. I mean, we usually get a good turnout for these things, but this is fantastic.
And I don't know if anybody knows how many people were online, but again, we have probably at least this many people watching online as well.
Urgency of the moment. So I'm wondering, first of all, as to Professor Schwinn, whether the question of weight classes in sporting events has ever been raised in any of these in any of the litigation regarding gender, like reorganizing amateur athletics as it's done in wrestling, where you have weight classes. Okay, so that's one question. The other question is what's the unitary executive theorist's response to the express language in the Constitution about faithful execution as being one of the president's express duties under the Constitution? Take care that the laws be faithfully executed. How do they circumvent that?
I'll just comment briefly about trying to design sports in a way that would accommodate differences across sex. I think maybe it's a generic way of saying what you're saying. And yeah, people have put thought into that idea. And in fact, it came up in these cases at the Supreme Court. The cases were tailored to actually raise that kind of issue. So remember, we had a 15-year-old girl, right, who, when she wanted to participate in middle school sports, had not yet gone through had not yet matured. And so she was taking therapy and had long identified as a girl at that point. And, you know, the evidence was pretty good that she didn't have an advantage as a middle schooler one way or another over biological females who were playing the same sport. And then compare that with the Hecox case is why that pairing came up. The justices just didn't bite. They just didn't see it that way. And part of it was relaxing intermediate scrutiny. What they said was, we're at intermediate scrutiny, we don't need to take a deep dive into those questions. We're just going to take the state's word for it, what their interests are, and that their interests more or less align with what our perception of biological sex differences are. That's good enough for us.
Sure. Briefly on it's a great question on faithful execution. So using the majority opinion in Slaughter as a sort of to reflect the at least one iteration of the unitary executive theory, the majority actually relies affirmatively on the faithful execution clause as part of their rationale for needing a president who can not only appoint with Senate approval, but also at will remove employees throughout the executive, including members of these multi-party boards, these bipartisan boards. So it's an excellent question. One could see it used the other way, but at least the majority here uses it quite affirmatively as part of, and really a founding part, a textual part of the unitary executive theory.
How about back to the side?
Thank you. This is for anyone who is able to answer this. I'm wondering if you get the sense of a growing consensus of what to do about the court, if there are heard rotating judges, panels, expanding the court, term limits. There's obviously a wide variety of reform options. I'm just curious if you get the sense of like a growing consensus around any of those options. And obviously there's like constitutional and practical, hoops to jump, but just curious to sort of the state of play on that.
Kevin or Aziz, my guess is maybe you've been in the middle of some of those kinds of discussions.
I think that there is a broad consensus that the Supreme Court is unrepresentative of either any kind of objective account of constitutional meaning or in some way responsive in the way that Barry Friedman, his professor at NYU, suggested in an important book about a decade ago, responsive to the will of the people. The problem, I think, arises when it comes to remedying that, because on the one hand, almost all the proposals that one can imagine that are obviously constitutional are also inefficacious. So I think ethics reform falls into that category. And many of the proposals that are obviously efficacious are almost certainly going to require a constitutional amendment. So term limits, I think the argument that I can give you a kind of Rube Goldberg argument about why we can do term limits without a constitutional amendment, but I think honesty would require me to say this is a Rube Goldberg argument. My own view, which is not an orthodox view, is that you cannot fix the court without fixing Article 5. Article 5 of the Constitution sets out the conditions for constitutional amendment, and it makes it, in practical terms, exceedingly difficult, if not impossible, in our current moment. It also channels it, as Ross Feingold, the former ACS president, noted, through a state-by-state process which weights the process toward rural states in a way that tilts in obvious partisan ways today. But it is because of Article 3's difficulty that pressure for constitutional change, which manifests in Justice Barrett's case, it was something like $40 million of spending around the confirmation, right? That political pressure, because it can't go through Article 5, gets sluiced into the Supreme Court nomination process. So the difficulty of Article 5 is the cause of our hyperactive activist court. And it is also the reason that the court can't be remedied, because in other jurisdictions around the world, every single other country in the world has an easier to amend constitution than ours. Almost every state has a way easier to amend constitution than ours. And when a court reaches a decision that is substantially out of step with the preferences of some supermajority of the people, which you can define in different ways, there are correction mechanisms. And so the court doesn't have the stakes it does here in other countries because it can be corrected. So both at the front end and the back end, the reason for the problem that is the Supreme Court, I get to say that because I don't have to litigate, is Article 5. And so my view is, well, if you're going to fix it, fix it. And fixing it means fixing Article 5. that actually don't just lower the threshold for constitutional amendments, but actually make that process a democratic process as opposed to the quasi-oligarchic process that is there now.
I think we have time for one more question. Could we rotate sides back here? The gentleman in the gray shirt.
I have a less sophisticated question. In my lifetime, the people who are now in power, but their parents and others supported George Wallace, Orville Faubus, and the right, and the rest, always preached states' rights, and they were very much opposed to the federal government. Are those days over now that they're in control?
I'll take I'm sure we all have thoughts about that. I mean, I'm sure we all have thoughts about that, but I'll take a crack at it. Interestingly, times like this, the flip side of that is that during times like this, liberals and progressives discover the values of federalism and doing what they can in states. I'm not a historian. My reading of the states' rights time and arguments was that there were always people who did have a principled view about the nature of government being closest to the people and the role of states versus the role of the federal government. Those debates obviously go back to the framing and the Federalist Papers. But I think probably for many people, those arguments were simply expedients. And ways of dressing up in noble sounding language, a way to get done politically and legally what they wanted to do. And I think we see that same kind of dichotomy today between there are people who have principled commitments to certain legal frameworks and ideas and others who are just using them as expedients. So, okay. Once again, we like to honor our time commitment to you by getting you out of here on time. So thank you once again for joining us. We hope we'll see you again next year. We plan to keep doing this.